This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Securities and Exchange Commission is suing Elon Musk for a third time. This time, the agency says that Musk cheated Twitter shareholders out of more than $150 million by waiting too long to disclose his growing stake in the company as he prepared a takeover bid in 2022. The SEC complaint accuses the billionaire of failing to promptly report that he had amassed more than 5% of the social media platform's stock in early 2022, a revelation that would have sent the stock's price up. Quote, because Musk failed to timely disclose his beneficial ownership, he was able to make these purchases from the unsuspecting public at artificially low prices. A lawyer for Musk disputed the charges, saying the billionaire has done nothing wrong and everyone sees this sham for what it is. Joining me is securities law expert James Park, a professor at UCLA Law School. Jim, tell us about the SEC's complaint.
Well, there was a violation by Elon Musk of Section 13D of the Securities Exchange Act, which says that any person that acquires more than 5% of a company's shares has to file a report with the SEC within 10 calendar days after crossing that threshold. And simply put, Musk did not file that report. And so it's a very clear violation of a well-established SEC rule. And I suspect that the SEC wants to send the signal that this is a rule that has to be followed. I think that's one explanation as to why the case is being brought now.
As you say, it seems like a simple case, sort of cut and dried. SEC started investigating this in 2022. Why did it take so long?
It's a very good question. It has been a few years, and, there are a number of possible explanations. One is that, they're busy doing a lot of things. As you know, over the last few years, they've been working on a lot of various rule proposals. They've brought some very interesting, ambitious enforcement cases. They may simply have been busy. Another possibility is that there may have been some debate within the SEC about, should the case be brought, given that, we have brought prior cases against Elon Musk that have been settled, and they've been very high profile. He's been somebody who has vigorously opposed the SEC. And maybe the thought is, well, we bring another case right now. Maybe the perception is that we are targeting Elon Musk. And another possibility is maybe there was some debate about, okay, there's a violation. What exactly is the harm? What exactly is the impact on investors? The purpose of the rule, when it was originally passed in 1968 as part of a law called the Williams Act, was to give the management of a corporation some notice when somebody was interested in taking control over the corporation so that they could react. So they might implement various defensive measures to make it more difficult for a hostile takeover to succeed. And as we know, Elon Musk eventually did successfully acquire Twitter, and it was actually forced to do so at the end. He tried to back out and was forced. It would be sort of a, interesting question as to, can you argue, well, we were harmed? Was the company harmed when at one point they actually were trying to force Elon Musk to take over Twitter, right? And so, I think those are all things that, that could have contributed to the length of time it took to file the case.
So you don't think that it was sort of a last contentious kind of act by the outgoing head of the SEC, Gary Gensler?
It certainly was a last act, and whether this was meant as sort of a final, let's poke at Elon Musk for some political reason, I'm skeptical that that's the reason. But I do believe, I think this is somewhat obvious that, maybe there's a concern that the next administration may not pursue the case. And we believe there's a case here, so we should file it while we can. I think that it's certainly a possibility that was what happened. And, the other possibility is, it just took some time to figure out all of these issues and come to a decision. And they just had more time, in the fall or late fall after the election to come to conclusion on some of these more difficult issues. That's also a very real possibility, that the timing was simply that this is when they finished their deliberation as to whether or not to bring the case.
Musk's lawyer, Alex Spiro, said the agency has waged a multi-year campaign of harassment against Musk, but filed a, quote, a single-count ticky-tack complaint. Now, what's your reaction to that single-count ticky-tack complaint? I'm not even sure what that means.
Well, it's true that it is a single count. It's a violation of Section 13D, no other provisions indicating he committed securities fraud. There's nothing saying he acted with fraudulent intent. It's just simply a strict liability violation of a very simple rule. You might liken this to a speeding ticket, right? You violate the speed limit and you get a ticket, and that's the law, right? And, the SEC's response is, the law is the law. If I'm caught going over 65 miles per hour, then you get a ticket. Now, what the defense may say is, well, and as you know, sometimes, the police do not enforce the speed limit. And, you go a few miles over and the police officer is busy, has better things to do. They're not going to write you a ticket. And so there might be an argument, well, the SEC could have used its discretion not to pursue an enforcement action in this case. I think, though, that would be problematic when you have such a clear violation that's been highly publicized to say, we're just going to let this go. If you believe that 13D matters and is important and should be enforced, then, I think that the SEC would say that this is an opportunity to show that this rule is something that we treat seriously, and you can't just violate it without paying a penalty. And I think there's some merit to that argument, because 13D is an important provision. In fact, there's a huge amount of debate, and there were rules that strengthened 13D that were passed a year or two ago. And there's an argument that this is a very significant rule that serves an important purpose. And if we let it go unenforced, that's a problem for the SEC.
Taking that into consideration, that it might look bad if the SEC drops this case when Trump takes office, but also that Elon Musk seems to be Trump's new best buddy. Do you think there's a hazard in them dropping the case?
Certainly. I think that, the new SEC, I think, will look at a lot of different things as to how they pursue the case. I would be surprised if they dropped it completely. What they could do is quickly allow it to settle for a nominal sum, right? I think that's a more likely outcome. And, there would potentially be some criticism while you're doing this because there's a sort of political reason why you're letting him go with a slap on the wrist. And I think that's something that they'll have to keep in mind. And I think in addition to that, they will also have to consider how important do we think Section 13D is? What kind of message would it send if we let him go with a slap on the wrist? And that's in addition to the question of whether or not there's favoritism going on with respect to Elon Musk. And, I would add that I think, part of the reason the SEC might have felt like it had to act is it didn't want to create the impression that just because, we have an individual who has been highly critical of us, we're not going to be scared off by that. That would send a bad message as well if we simply are intimidated and not, bringing cases for clear violations against that individual simply because we brought cases against him in the past and he has used this platform to criticize us.
He certainly has. I've been talking to Professor James Park of UCLA Law School about the SEC suing Elon Musk, saying he cheated Twitter shareholders out of more than $150 million by waiting too long to disclose his growing stake in the company as he prepared a takeover bid. Apparently, Musk rejected a settlement offer, and reportedly the settlement offer was more than $200 million to settle this. How does that compare to other fines under this section?
It's a large sum. It's a large sum, and the way they would, I think, justify that is The theory is that if he had disclosed in a timely manner, the stock price would have gone up because other investors know he's interested in buying for some reason. And, the cost of buying those shares might have been an additional few $100 million. And so I think that the SEC's rationale might be that, you got a bargain on these shares because anyone else would have filed a Schedule 13D with the SEC. The stock price would have gone up and you would have spent hundreds of millions of dollars more to buy the Twitter stock that you wanted to buy. And so their argument is that the shareholders who basically sold their shares in the market to Musk were cheated in a sense because they were entitled to some disclosure that this was going on, and that might have been their justification for what is a fairly, seems like a fairly high penalty to me, but it's probably based upon the harm to investors, and so that's the argument that might have been made. Now, on the other hand, you might say, well, that's a lot for something that, is it an intentional violation? And that's something where, there's some indication that at the very least, maybe he was reckless and didn't care about the rule. And so maybe another argument for a higher penalty is that, you need to figure out what the law is before you act. And so I think those are the reasons the SEC might justify a high penalty.
Yeah, so I read that Alphabet paid $750,000 to settle allegations that it failed to file timely reports, and that almost 24 firms and individuals were cited in September for not submitting proper reports about their holdings and transactions. So it doesn't seem to be out of the ordinary.
Yeah, there are penalties all the time that are imposed. You could argue that in this case, it's the sheer amount of purchases that were made, maybe that might justify an even higher penalty than the ones that were imposed before because of just the market impact. I don't know what the market impact of those other cases were, but given the volume or the amount of shares he's buying out in the marketplace, there might be an argument that, well, there's more potential investor harm or unjust enrichment by Mr. Musk that could justify an even higher penalty than past penalties the SEC has imposed for these cases.
Let me ask you this. What's your take on Paul Atkins, who Trump says he's going to nominate to succeed Gary Gensler?
He's been a commissioner before, so he knows the SEC. He certainly has a different approach than Mr. Gensler, and I think it reflects, probably a more conservative view with respect to the role of securities law and more of a concern for reducing regulatory burdens on public corporations and other market participants. He knows securities law. He has views on it, and whether or not you disagree with those views, I think he's an appropriate choice for the position. And I think there's a lot of difficult issues he's going to have to grapple with, and I think crypto regulation is one of them. And the Third Circuit sent back the various rules to the SEC and said, give us a better reason why you're not writing rules on crypto, and that's going to be owned by the Atkins SEC, whatever essentially comes out of that process. And the danger here is that if you're perceived as being deregulatory and something really bad happens, then there'd be a tendency to kind of put the blame on you. If there are a lot of crypto losses, for example, then everyone's going to be pointing at the Atkins SEC. And so those are things that he's going to have to navigate as he enters this job.
It's always interesting to watch what happens at an agency when there's a new administration. Thanks so much, Jim. Always a pleasure. That's Professor James Park of UCLA Law School. It's one of the most destructive natural disasters in Southern California history, killing at least 25 people and destroying thousands of homes. And while crews continue to battle the wildfires, the investigation into the cause of the devastating fires is intensifying. ATF Special Agent in charge of the LA Field Division, Jose Medina, says they're tackling the investigation from all angles.
Investigators are looking for remaining fuels and surviving fire patterns, as well as fire patterns on non-combustible materials, such as rocks, cans, bottles, etc. We have conducted interviews with individuals that initiated the 911 calls and the first responders. We are talking to individuals about not just what they saw, but what they smelled and they heard.
In the meantime, litigation over the fires has begun. Lawsuits on behalf of homeowners, renters, business owners, and others have been filed against Southern California Edison over the Eaton fire and against the Los Angeles Department of Water and Power over the Palisades fire. Edison International Chief Executive Officer Pedro Pizarro told Bloomberg on Monday that the utility didn't detect any electrical issues on a transmission line near the start of the deadly Eaton fire.
Certainly, we've seen the video images and photos that are in the media that a number of residents have taken showing flames near our towers. Up to date, we have not seen in our telemetry any indication of an electrical anomaly. And typically, when you have a fire caused by electrical infrastructure, you do see a signature, voltage dropping, current increasing. We have not seen that in our study.
Joining me is Bernie Bernheim of the Bernheim Law Firm. I know you're going to be filing your lawsuits in the next few days. What's alleged in the lawsuits filed against Southern California Edison?
They allege that essentially that the power company for the Eaton fire, which is Southern California Edison, their equipment started the fire and that the equipment was negligently maintained and operated.
So on Monday, Edison CEO Pedro Pizarro told Bloomberg News it didn't detect any operating anomalies on its transmission wires in the 12 hours before the fire. What will you use to make out a case for negligence?
Well, first of all, there's video of of the fire starting under their equipment, a giant shower of sparks, number one. And that video is widely available. Number two, there's essentially a tracking service that shows when there are anomalies in the electrical grid, and the average is like 2, 3, or 4, but it detected over 100 in the hours before the fire. And at that point, power should have been shut down, and it wasn't. So, with all due respect to the CEO of the company, there's ample evidence to indicate that they're responsible. Now, like with any lawsuit, there's going to be discovery. We are only going on what is publicly available right now. But once, discovery is done, documents are obtained, depositions are taken, the actual truth of what occurred is going to come out. And if their equipment, the fact that the fire started right under their equipment is pretty telling. And what does he say caused the fire if it wasn't his equipment?
California has this unique doctrine that a utility can be held liable for property damage when its equipment ignites a fire, even if it didn't act negligently. Tell us about that doctrine known as inverse condemnation.
Yes, because there was a taking of property, is the term that's used, by a government or quasi-government entity. And, there's been sort of a legal debate about whether utilities qualify. Most commonly you see, and there's that they do qualify. But initially, in earlier fires, the utilities fought this idea. They said, look, we're not a government entity. We're a publicly traded company. You can buy stock in us. But the courts here in California have decided that they qualify as quasi-government entities against whom inverse condemnation can be alleged. But inverse condemnation originates where, let's say, the government, the county, let's say, says it's safe turns out that it wasn't safe to build. There was a big mudslide, and all of the the houses that the government or the county, let's say, or city said were okay to build on, slide into the ocean, right? Well, they basically condemned the property, and a version of it comes when the government takes property, like to build a highway or something. That's the underlying principle, where then if they're going to take your property, build a highway, they have to give you fair compensation for that taking. That's where it originates from. And then it's kind of it becomes a taking when they create conditions under which you lose your property. They create conditions under which you lose your property.
The CEO on Bloomberg said that California has in place this provision that allows a utility to remain financially healthy, even if it's found liable for the wildfire, including a $21 billion fire insurance fund that caps the company's exposure at $3.9 billion. Suppose the claims exceed $21 billion. What happens then?
I don't know. That has never been an issue before.
Because some of the estimates for this fire are well above.
Yeah, we don't know. It's uncharted territory.
What kind of damages would you be seeking in these cases?
Well, there are damages for the damage to the property, the real property. There's damage to the personal property. There is additional living expenses that people incur when they have to leave. There is also physical injury that can occur sometimes, not just because you're burned, but we've had children in other fires who develop asthma and so forth. There's psychological injury. You could call it emotional distress. There's also the annoyance and other aggravation that comes from the rebuilding process and loss of use. There is often business loss associated with it. Sometimes it's because literally a business was damaged or destroyed. For example, when we did the last Malibu fire, a big one, we had quite a few of the rehabilitation, drug rehabilitation centers that had business loss, or we represented owners of gas stations and car washes, all kinds of jewelry stores, all sorts of businesses. And then we've also represented clients who had home businesses operating, sometimes very substantial home businesses with millions of dollars of loss, especially now that a lot of people, combine their home and their business. There's also interest, the loss of use of money, which we generally recover at a rate of 7% simple. And there's also the attorney fees and expenses of litigation.
And how long do these cases generally take to litigate?
Years.
Also, property owners in the Pacific Palisades are suing the Los Angeles Department of Water and Power, claiming that a reservoir that had been drained and not repaired, coupled with inadequate water pressure in fire hydrants, undercut efforts by firefighters and ultimately allowed the fire to spread out of control. It alleges that the utility's negligence turned homeowners to homeless in a matter of hours. Is that lawsuit tougher to litigate than the one against Edison?
Yes, and that's being done in connection with the Palisades fire, where the damage lot runs up and down the Pacific Coast Highway. And the reason that the lawyers have filed that, and we're still investigating and deciding what the viability of that is because there was not a power company to sue. In other words, there's no evidence so far that a viable, private defendant or quasi-public defendant, or essentially a deep pocket defendant caused that fire. So what at least one law firm has decided to do is exactly what you said, sue over the mismanagement of a particular reservoir that wasn't available. And one of the things I know that's being alleged there in connection with the Palisades fire is that not only wasn't there sufficient water, but they did not inform the fire company, the fire department, that certain, I guess you would call them cisterns or, reserves of water were empty when they should have been filled. But there's an issue there of immunity, sovereign immunity, because there are statutes that they are asserted by the city, by the Department of Water and Power, that provide immunity for these kinds of decisions. You can't sue them. Now, just because immunity is available as an affirmative defense to the city does not necessarily mean that the city will assert that immunity. And one could say, well, why on earth wouldn't they assert that immunity, right? I mean, that throws the case out of court. But remember, there's a political, social component to this. Many of the victims of the Palisades fire do not have insurance, as insurers pulled out of California not long ago, like State Farm, or many did, or they're very underinsured. So you have people that if they cannot sue the city, they have very little redress. I mean, whatever little FEMA aid or SBA loan aid you're going to get. And, they could go out into the streets with pitchforks, and it might look very bad for the city if the city says, well, we can't really refute that we were negligent, but we do have this immunity, and we're going to hide behind this shield. And that could result in, the whole city council and, the mayor and everybody being thrown out. And they may decide, I'm not a politician, but they may decide that, look, it's better for us to pay at least something into this than just to take the position that, neener, you can't sue us even though we screwed up.
Thanks so much for being on the show. That's Bernie Bernheim of the Bernheim Law Firm. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.